Good evening, everybody. As chair of the Law Reform Committee, I'd like to welcome all of you to the 21st Annual Law Reform Lecture, which is called Reimagining Law for the Earth. As ever, the training and events team at the Bar Council and Eleanor Lamarck, who's our policy assistant to the Law Reform Committee, have been absolutely vital in organising this event, and I want to extend the committee's sincere thanks and my personal thanks to each and every one of them for the work that's gone into organising this. We've had a really busy evening, but as we brace ourselves for the general election day after tomorrow and the plans for law reform that may follow in the coming months, we as a committee are adopting, as ever, a politically neutral stance, but we encourage every government to uphold the rule of law and seek to assist those who seek our assistance in reforming our laws across a very wide array of practice areas. And we could not do that without the very many hours that my committee members put in, and those who kindly agree to be co-opted into numerous working groups to draft responses to the many consultations that come out every month. And my committee includes my three fantastic vice chairs, Dominic, Selina and Edith, and I hope you will get to speak to many of the committee members at the drinks reception, which follows immediately after this lecture. So we are absolutely delighted to have secured the attendance and goodwill of our wonderful panel of expert speakers, each of whom has agreed to give up precious time for us this evening. And they are drawn from the worlds of legal academia, legal practice and legal activism, with a very healthy and vibrant intersection between the three areas. And I will share a few words about them in just a moment. We're very pleased to have such a great turnout for this evening. We're sorry that some people who wanted to attend couldn't, but I am pleased to say that the lecture is going to be recorded this evening and it will be shared online by the Bar Council in due course. With that in mind, I would be really grateful if everyone could just make sure, take a moment to see that your mobile phones are switched off or on silent. And if you wouldn't mind not taking photos or video footage, as I've said, we will have video footage available in due course. So as promised, I now want to introduce our speakers and panellists for this evening. First of all, sitting next to me, you'll be hearing from Dr. Helen Dancer, who was called to the bar at Middle Temple in 2001, and she practiced not so far from here as a barrister, specialising in child and family law before moving into academia. She is a senior lecturer in law and anthropology at the University of Sussex, and she has conducted ethnographic fieldwork in Tanzania, the UK and Ecuador, as well as presenting her research around the world. Helen jointly leads the UK Earth Judgments project, and we are delighted to announce the launch of UK Earth Law Judgments, Reimagining Law for People and Planet. The very first hard copies, in fact, arrived by post here today. In fact, the authors saw them for the first time here. And that is an anthology which is being made available on a generous open access basis and published by Bloomsbury, should you wish to get a copy of the book. In looking at 11 judgments, it draws from a range of earth law approaches, including rights of nature, animal rights, environmental human rights, well-being of future generations, ecocide and reinterpretations of existing legal principles. A must-read in my humble opinion. Helen's colleagues from the University of Sussex, who jointly led the UK Earth Judgments project with her and who will take panel questions later on, are Dr. Helena Howe, who is a senior lecturer in law at the University of Sussex. Her research lies at the intersection of property, environmental and animal law. Her current work focuses on multi-species justice in the law and the policy of farming and on the legal regulation of animal breeding, for which she chairs a working group of the UK Centre for Animal Law. Dr. Bonnie Holligan is a senior lecturer in property law. Her research looks at how property rights shape and are shaped by our social and ecological relationships. She co-leads the University of Sussex Environmental Justice Law Clinic, which works with the Environmental Law Foundation and other external partners. Also joining us as very welcome guest speakers tonight are Zoe Loventhal-Casey and Kyle Lishak. Zoe is a member of Matrix Chambers and practices in all areas of public law, human rights and environmental law. And she's been involved in many of the leading cases in these areas in recent years. Zoe was a founder member of the Bar Sustainability Network and sits on the Bar Council's Climate Crisis Working Group. In 2024, she was nominated in the Legal 500 inaugural ESG Awards as one of the Bar's sustainability champions. Zoe was elected as a local councillor in 2023, and she dedicates time outside the law to a number of environmental projects in Warwickshire, including river restoration, rewilding and air quality. Kyle is a practicing international lawyer and currently the head of UK at Client Earth, where he leads on a number of initiatives focusing on environmental advocacy within the United Kingdom. Previous to this, Kyle was head of legal at the Met Office, the UK's National Meteorological and Climate Service, for more than 7 years. And before that, he worked as principal solicitor at Natural England. He's also worked in private practice and within the environmental, non-profit and public sectors of the United States. Well, we all know that Wimbledon started this week, and I was very pleased to see Sir David Attenborough in the audience the other evening when commentators tried to identify a bird on court, and the cameras naturally panned towards Sir David Attenborough. And it was Sir David Attenborough who has said in narrating his documentary series, Life on Earth, the fact is that no species has ever had such wholesale control over everything on Earth, living or dead, as we now have. That lays upon us, whether we like it or not, an awesome responsibility. In our hands now lies not only our own future, but that of all other living creatures with whom we share the earth. So from those lofty and important words to the more administrative matters, let me just conclude by saying, in the great tradition of addressing a full house, I need to remind you that in the event of a fire alarm, it's not a drill, it's the real thing. Please follow the instructions of any Inner Temple staff or bar council staff, and the assembly point is the lovely great big tree out there, which is opposite Pegasus. So without further ado, I'm going to introduce our first speaker, Helen Dancer.
Thank you very much, Alina, for that wonderful introduction. And on behalf of my fellow editors, Helena Howe and Bonnie Holligan, who are sat at the front here and will be joining us later, thank you for this kind invitation. It really is an honour for us to be here and to share this new book with you. So to sum up, this book is about legal possibilities. It's about how we can use law to make a difference for people and planet. And it's the result of 4 years of collaborative work between 22 legal scholars, as well as artists and young people. We have been inspired by places around the UK, but also by human relationships with the land, the water, the air, and other beings. We've also been inspired by the past, the present, and the future. And in reimagining law for the earth, we drew inspiration from legal developments that are happening both here in the UK and around the world. I'm going to turn to what we mean by earth law in a moment, but first I'd like to tell you about why we embarked on this project. So Bonnie, Helena and I are colleagues at the University of Sussex Law School, and the idea for this project grew from our diverse individual research interests, for example, in the field of earth law, forests, property law, and animal law, but also from a vision that we share to imagine how law could foster healthier relationships between humans and our more than human world. So for this book, we were inspired by the work of other critical judgments projects that have happened over the past 18 years, including feminist judgments projects and the Australian Wild Law Judgment Project. So for anyone who might be unfamiliar with the idea of critical judgment writing, this involves rewriting an existing judgment using a particular normative lens, for example, feminism or human rights, to create a comparator with the original decision. This technique was developed by feminist legal scholars in Canada and later the UK. And in the words of Lady Hale, who provided support for the English Feminist Judgments Project back in 2010, she says, the business of judging, especially in the hard cases, often involves a choice between different conclusions, any of which it may be possible to reach by respectable legal reasoning. The choice made is likely to be motivated at a far deeper level by the judge's own approach to the law, to the problem under discussion, and ideas of what makes a just result. So once we acknowledge that judicial decisions are informed not only by legal reasoning, but also by other knowledges and motivations, we can see why it's important to recognise that these other motivations exist and reflect on their implications for making claims and deciding cases. We should also think about who makes legal claims, whose voices are heard in court, and who decides cases. And we wanted to apply this approach using an earth law lens for the UK. So why Earth law? Well, we all know we're living in an age of massive uncertainty and planetary crisis. And we need systems and approaches to law and governance that can meet the challenges of these uncertainties. Intergenerational equity. And we need to repair the harm that humans have already caused to our planet. We need to increase resilience for the future and ensure that there is a habitable planet for future generations. The core problem at the moment is that the values that underpin many of our current legal and policy frameworks do not address adequately, and in many cases facilitate overconsumption of the planet's resources and human inequality. Earth system scientists and theorists argue that humans, in their most powerful position as Earth's dominant species, have the capacity to govern and to regulate to ensure a habitable planet. We know that there's been growing political and public awareness of the planetary crisis since the 1970s, and global agreements and conferences have taken place to try and tackle this. But we also know that we haven't yet established effective frameworks for action. Earth law approaches recognise the need for fundamental change in the way that we think about these problems, in our ethical commitments, as well as our laws and systems of governance. So what exactly is Earth law? Well, Earth law is an emerging range of theories and legal innovations that are still taking shape in response to the planetary crisis. There is considerable diversity of opinion within Earth law. But what the various approaches seem to share is an emphasis on interconnectedness, interdependence, relationality, an understanding of our place as humans in a more than human world. In fact, globally, Earth law has been evolving rapidly over the past 15 years, and particularly during the lifetime of our project. So I want to give you some examples from the UK and beyond to illustrate what we mean by Earth law. Firstly, an example from the UK. In 2015, the Welsh Assembly passed the world's first Wellbeing of Future Generations Act. This act reflected public concern to solve long-term challenges and meet the needs of present generations without compromising the ability of future generations to meet their needs. Rights of nature is another Earth law concept. It's been used particularly to protect forests and rivers. Ecuador was the first country in the world to enshrine the rights of nature in its constitution in 2008. But rights of nature laws have also been implemented in countries as diverse as the United States, Bolivia, New Zealand, Bangladesh, Canada, and Spain, to name a few. The human right to a clean and healthy environment is another example. And this has now been recognised in the laws of more than 80% of United Nations member states, although not to date the UK. There is growing global recognition of the importance of Indigenous peoples' rights and knowledges in state laws, constitutions, and case law, particularly that of the Inter-American Court of Human Rights. We also now have greater insight into multi-species relationships, the interests of farm and companion animals, as well as the impact of intensive agriculture, fishing, and deforestation on wildlife, zoonotic disease, and human health. These insights are advancing ethical debates and law on farming and the treatment of animals. For example, the recent UK Animal Welfare Sentience Act in 2022. Some countries have enshrined the crime of ecocide in their law, and this enables prosecution of serious environmental crimes. In fact, includes a recent 2024 European Council directive. International lawyers in this country and abroad, together with the UK-based organisation Stop Ecocide, have also drafted a proposed ecocide law for the International Criminal Court. We also see young people and adults around the world bringing a wave of human rights-based climate change cases against governments. In this year alone, between April and June, there were several landmark decisions on the legal obligations of governments to address climate change effectively, including the European Court of Human Rights Swiss Senior Women's case, and 2 cases from this country, Friends of the Earth and Client Earth were involved in one, and the recent decision of Finch on environmental assessments from the Supreme Court. We can also find elements of Earth law in existing law. So authors in our book have drawn from, for example, the human right to property, the Sanford principle governing national parks, and the precautionary principle to prevent environmental degradation. So all of these are examples that we would put under the umbrella of Earth law. Now, in the book, we take the view that Earth law should not be thought of as a subset of environmental law. Quite the opposite, in fact. The judgments in our book have also engaged with areas of law that would be considered beyond the scope of environmental law, for example, employment law and family law. Our aim has been to explore Earth law in its widest sense, not simply as a replacement for environmental law, we don't think it should be replaced, but as a range of approaches that could ultimately underpin all areas of law. So how did we develop and use Earth law in the book? Well, most of the Earth law approaches that we used have not yet been adopted in UK law. So in developing the collection, we recognised the importance of looking beyond the UK context and exploring a plurality of approaches. The overarching theme that guided the contributors was how relationships between people, place, and the more than human world are produced, transformed, and destroyed through law. And we invited the contributors to adopt an Earth law lens of their choosing for reimagining their judgment. There are 11 judgments in the book, and each chapter contains a judgment which is introduced by the judgment writer, as well as a commentary written by someone else, another author, to offer an alternative perspective. 2 of the chapters also contain artworks that were produced either by or with the judgment writers, including a judgment which actually takes the form of an artistic performance that you can see online, and a wild law judgment generator that uses artificial intelligence to generate judgments. We wanted the judgments to reflect a variety of contexts around the UK, where relationships between people, place, and the more than human world have been contested. So if you read the judgments, they will take you from ancient woodlands to post-industrial mining landscapes, from polluted water to estuary fishing grounds, from the cultural landscapes of the Lake District and Stonehenge to wind farms in Scotland, from the interests of wild mammals to what it means to be a good farmer. And 2 of the judgments looked at the actions of British companies overseas and how they could be held accountable for environmental harm in the UK courts and in the International Criminal Court. In some of the cases, the changes that we made in the judgments were very subtle, and in fact, the cases could have been decided in that way originally. Other judgments engaged in time travel to incorporate laws that did not exist at the time of the original decision, but do now. Others were more speculative, requiring entirely new legislation or drawing upon norms from other jurisdictions, such as the crime of ecocide or the rights of nature. But in all cases, our imaginings sought to demonstrate the possibilities of how Earth law could transform relationships between people and planet. So I want to just give you 3 examples from the book to illustrate how we did this. The first example is my own judgment, which was inspired by the 2020 case brought by the television presenter Chris Packham. The case concerned the government's decision at that time to proceed with the HS2 rail project. I decided to draw from Welsh law, reimagine the public law test of reasonableness through the lens of the well-being of future generations. I interpreted the principle to encompass the interests of both human and non-human generations. I thought about the significance of emotion in legal claims concerning the environment and how judges respond to this in their judgments. Given the future generations lens, I drew inspiration from Mr. Justice Peter Jackson, as he then was, in the family law case of Re A Letter to a Young Person. In that case, he wrote his judgment in a letter to a 14-year-old boy. So I wrote my judgment as a dissent in the form of a letter to future generations. And I shared it with two 14-year-old young people who provided the commentary for the chapter. This forced me, as you can imagine, to strip back legalese, as Lord Justice Jackson had done in his judgment, and to hold myself directly accountable to those generations for my decision. A second example from private law is Helena Howe's judgment, which reimagines the tort law case of Savage and Fairclough. She explored the point at which the operation of intensive livestock farming should amount to a private nuisance. Her judgment is based on a reimagined framing of the good farmer test. In Helena's judgment, the good farmer is compassionate and knowledgeable, sensitive to risk and ethics of care between humans and other beings. Her judgment acknowledges a wide range of harms associated with intensive farming, and a wider range of harms associated with intensive farming than in current law. This included the perspective of the pigs that were kept by the dependent farmer. An example of an entirely speculative judgment is Rachel Colleen's judgment on the environmental harm caused by oil exploitation in the Niger Delta in Africa. Rachel stepped into the International Criminal Court to imagine what a reparations order for a possible future crime of ecocide could look like. Her speculative judgment concerned a claim against a fictional employee of a UK registered company, and Rachel adopted Polly Higgins's definition of ecocide to bring attention to the importance of criminal liability for omissions as well as acts that are associated with significant ecological, climatic, human and cultural loss. So these are just three examples of the variety of approaches that the contributors in these 11 judgments took. And if you read the book, we would invite you to think about the cases that you have worked on and consider how the variety of approaches that are covered in the book could open up new possibilities for advocacy and decision-making in your area of law in the future. Now, there are, of course, many challenges in developing novel legal approaches. For example, when it comes to representing non-human beings, we think that humility and considerateness are particularly important in attempting to speak for other beings or entities. On the subject of personhood in particular, the judgment writers offered a complete spectrum of views on whether non-human legal personhood should be used as a vehicle for representation in the UK. As editors, we really welcome this diversity of opinion to open up debate on a complex issue. As editors, we would argue for sensitivity in attempts at representing non-humans whose experience we cannot share, and the importance of paying attention to difference and acknowledging the limits of our own knowledge. Professional ethics is another important consideration. Ethics are the cornerstone of legal practice, and the entire ethical framework for lawyers is underpinned by the principle of the rule of law. A commitment to the rule of law is fundamental, but equally we think it's important to acknowledge that law as a discipline constructs and to some extent idealises a version of the legal professional self that may look somewhat different in practice. As Professor Stephen Vaughan has argued in his work on legal ethics, all lawyers have personal moral boundaries. They also have ethical agency to take responsible stances in the way that they both advise and represent clients. The book seeks to tread a path along these lines towards ethical practice that requires both acting with integrity in not knowingly inflicting harm on another, but also respecting professional codes of ethics and acting in the public interest. So finally, who is this book for? Well, the electronic version of this book is free for everyone to access, and we hope that it will contribute to legal education and continuing professional development for lawyers and judges. For example, through mooting competitions or as illustrations of judicial interpretation of existing law. For activists and cause lawyers, the book acts as a source of solidarity and as a contribution to the toolkit of ideas for future claims and advocacy. For artists, educators and the public, the judgments and their artistic interpretations provide material for engagement on topics such as the legacies of extractive industry, clean energy, sewage pollution, worker activism, nature conservation, human rights and animal welfare. So this is a resource for everyone. And the beauty of legal decision making is that it's continually evolving and each of us has a part to play, whether that's in teaching and learning, communication, activism, policy development, making legal claims or judging them. So whether you are a lawyer, a judge, an academic, a student, an educator, an artist, an environmentalist, if you work in law in other ways, this book is for you. Each of us has the power to make a difference in whatever capacity we are working in. And we hope that this book will inspire you to reflect and take action for the future. Thank you.
So much, Helen, and the beauty of having academics who are used to lecturing at these events is they've run perfectly to time. It's a skill I need to learn a little bit more. So we're going to take questions at the end. So I'll hand over to Zoe now for her section. Thank you, Zoe.
Thank you very much, Alina. So I have put together some slides because I think that often with questions like the one we're tackling tonight, a picture can paint 1,000 words. And the words are beautifully set out already in this book that I'm yet to read, but I want to read. Why? So just to start with the question, why? Picking up some of the threads that Helen's already started. Why do we need to reimagine law for the earth? And for me, the first answer to that is a conceptual one, and it's one which, when I'm thinking and I'm trying to suspend my normal legal mind, I go to literature. So I think the best answer to this is, why do we need to? And that's because of concepts like The Overstory by Richard Powers. I don't know if anyone's read it. People aren't the apex species that they think they are. Other creatures, bigger, smaller, slower, faster, older, younger, more powerful, call the shots, make the air and eat sunlight. Without them, nothing. Now, for those that have read Richard Powers' book, he's talking about trees. So there are times in life where we need to stop and think, what part of the world are we? We're only a very small part, with trees actually calling the shots. So that's my slightly waxing lyrical moment over. Return to legal analysis. The second question why, the second answer to the question why, is because of things like this. We all have our own images that tell us why we need to act. And these are some of my ones that go across my mind when I'm thinking about it. And it's because of facts like this. The UK State of Nature report from 2023, almost 20% decline in nature since 1970. Less than half of UK's biodiversity now remains. And we're now one of nature's most depleted countries. On a global scale, it just gets worse. Wildlife has reduced by 60% since 1970. We're in crisis, and we're already reaching, if not having already reached, tipping points. So apart from that, protecting nature is fundamental to mitigating the climate emergency. And fourthly, picking up the thread of the argument that's been laid down already, anthropocentric approaches to law with humans and even with sustainable development at their centre are patently failing us. So I ask the question, should nature therefore no longer be viewed as a resource for humans to exploit? And that's why I think we need to reimagine the law for the earth. So I've got 5 points that I want to make, and I'm going to emphasize one of them in depth, because that's the Ecuador model that we've already heard a little bit about. The 5 points, first of all, I just want to touch on some of the international models we have at our fingertips. Secondly, I'm going to take you to Ecuador, to the forest of Los Cedros, to think about how they've done it in Ecuador and how they've succeeded. Thirdly, I'm going to touch on ecocide as a concept. Fourthly, we're going to go to the International Human Rights Committee in the Torres Straits Islanders case. And fifthly, I'm just going to pick up some other themes before I finish. So firstly, the international models and why I would say they're not currently working. We currently have as our sort of global model, the UN Sustainable Development Goals and Agenda 2030, which are ultimately closely tied to economic growth. And all the UN models, member states, have signed up to them in 2015. But those models remain anthropocentric rather than ecocentric. And similarly, the IPCC and the COP processes that we've seen have so far not necessarily got us where we need to be going. We do, however, have also the UN Convention for Biological Diversity, which is has as its goal, fundamental goal, to restore 30% of nature by 2030. That was agreed at the Congress of the Parties on Biodiversity on 15th of December 2022, and it's now a core target of the coming Montreal Global Biodiversity Framework. But I ask the question, is this enough? And is it possible to achieve this without a paradigm systems shift, a reimagining of the kind that we've been thinking about here? I would wager no is the answer to that. But if we go across to Ecuador, that's my second point I want to spend a little bit of time on, we can get some amazing inspiration. You have a picture here of the cloud forest called Los Cedros in Ecuador. And in Ecuador, they have recognized that nature itself has rights which need protecting. And as Helen said, it's the first country which has enshrined the rights of nature in its constitution in 2008. And as a result of the 9 new members of the Constitutional Court in 2019, we have had some absolutely extraordinary judgments upholding fundamental rights, and centrally for these purposes, on the rights of nature. And I want to talk a little bit about one of those decisions in a bit of depth. Before I do, I need to tell you about Ecuador's constitution. I hope you can see the slides behind me. This picture is of a rather beautiful creature called the brown-headed spider monkey, of which there are only about 250 left in the world. And most, if not all of them, live in the forest that this case was about. And Ecuador's constitution starts in its preamble with the concept of celebrating nature, Mother Earth, Pachamama, as they call it in Ecuador, of which we are a part and which is vital to our existence. And in setting these rights out in their constitution, they have captured, I think, with quite a lot of beautiful language, the concepts that we're talking about. So we have Article 71. I'm not going to read it all out, but you can see for yourself the way in which it captures the essence of nature having the integral right to exist for its own sake, not just as a part of humanity and as a support for humanity, but for its own sake. And that's Article 71 of the Constitution. Article 72 is the right to restoration, the right to the restoration of nature, and the state's duty to effectively protect against any further damage. And thirdly, Article 73, which, as we will see, became critical in this judgment, is the precautionary principle that the state shall apply preventative and restrictive measures on activities that might lead to the extinction of species, the destruction of ecosystems, and the permanent alteration of natural cycles. So with these core principles at the heart of the Constitution, we then turn to this seminal case, which was about protecting not only the spider monkey, but also the jaguar, which resides in Los Cedros, the forest. So the basic facts at stake here were that mining permits had been granted to Ecuador's national mining company for parts of the protected forest, which, as we've heard, is one of the most diverse places on Earth. And so what the Constitutional Court did is identified the rights of nature threatened by the mining operations as having intrinsic value and rights of existence under Article 71, which we just saw, because, as they put it, the Constitution conceives humanity as part of nature. Therefore, the rights of nature necessarily encompass the right of humanity to its existence as a species. And so, although it might sound like a rhetorical lyricism, and it sounds rather lyrical, it's not just that. It's a transcendent statement and a historical commitment that, according to the preamble of the Constitution, demands, and I raise that for us today, a new form of civic coexistence in diversity and harmony with nature. So what did the court decide? Well, I've given you a little bit of analysis here. The court analysed each species and ecosystem in turn and considered what it calls the ecological tolerance principle, the extent to which any species can tolerate being under threat. And it observed a high level of risk of irreversible damage due to the great complexity of the ecosystem, the fragility in which the forest is found, and the threat under which several of its plant and animal species run the risk of extinction, and the consequent destruction of the ecosystem or permanent alteration of its natural cycles. And so, applying the precautionary principle, it identified 3 stages. In order for that to bite, there must be serious and irreversible damage. There must be scientific uncertainty, likely effects but inadequate evidence to assign probabilities, or simply scientific ignorance. And precautionary principles to the environmental lawyers in the room will be familiar. But it set out some quite specific limbs to apply in this particular context, and concluded applying this to the evidence and in light of the risks to nature. In simple terms, the mining permits granted in 2017 to Ecuador's national mining company should therefore be declared null and void. And that was that. Unbelievable, but there it is. That's the power of embodying the rights of nature in your constitution. And so, as we heard from Helen, this has had knock-on effects already. So we have a series of other constitutional decisions in Ecuador itself, but also other pending ones. We've got an increasing recognition by UN bodies of the importance of rights of nature. And we now have decisions in dozens of courts internationally, and the influencing of the adoption of other rights of nature laws in 14 other countries. So we've had the Supreme Court in Bangladesh upholding the right of the Turag River, which is pictured just there. And if you look on this link, ecojurisprudence.org, which I had a great time navigating in preparation for this, you've actually got a political and geographical map of the world, which plots each Earth Law decision, and you can go in and have a look. It's actually really fascinating. And there's an amazing discussion of the impact of the Ecuador constitution in the article that I cited there, which I was very grateful for when I found. So that's Ecuador, which shows what's possible. And the second point that I wanted to just pick up on was the concept of ecocide, which again is another way of conceptualizing Earth law. Now, as we know, the crime of ecocide has been recognised in various countries, but not yet the UK. The international crime in peacetime was proposed to amend the Rome Statute by an independent expert panel convened by the Stop Ecocide Foundation. And their definition is that ecocide means unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. There's actually an ongoing consultation on those proposed amendments by the chief prosecutor of the International Criminal Court in relation to exactly those proposals. And there's been a recent speech by the deputy International Criminal Court prosecutor who said the Rome Statute and international criminal law now face a challenge to their own relevance if they do not accept the need for such adaptation and flexibility in relation to the reality of the planet. Now, in the EU, we've had the adoption of the Environmental Crimes Directive, which effectively embodies ecocide principles into the criminal law in its directive. And so that means that all EU member states will have to adopt similar criminal law provisions in the next couple of years. So that will make a significant impact. And we do, in fact, have a private members bill that was introduced into the House of Lords by Baroness Boycott in 2024. But I think what's about to happen this week, we might have a little bit of legislative hold up before that progresses. But it's good to know that it's there. So that's ecocide. And then just for the last 5 minutes that I have, I'm going to touch on a couple more points. I wanted to take you on to my fourth theme, which is the Torres Straits Islanders case, which was a case brought by some of Kyle's colleagues at Climate Earth. This is a case about the reality of climate change for people who live in the tiny islands right at the top there in the Torres Strait, for whom the link with the land is absolutely basic to their everyday lives, to their cultures, to their ways of life, to their families. And it's also being destroyed in front of their eyes by the rising water levels. And the lawyer who acted for them, Sophie, actually lived there for a while, and I think herself felt the incredibly close connection between the land and life there. And so Sophie at Climate Earth assisted the clients who are pictured there to bring this case in the UN Human Rights Committee. And the Australian government was found to be in violation of the fundamental rights of the Torres Straits Islanders because their land was literally being washed away because of the government's inaction on climate change, and found a violation of both Article 17 of the International Covenant on Civil and Political Rights and 27, which was their right to ancestral homelands. And so we see, like in Ecuador, a recognition, not through the earth law principles necessarily, but through a recognition of the connection between your land and your human existence as being so close, particularly for indigenous populations. And that's exactly what the committee took into account: the islanders' close spiritual connection with their traditional lands and the dependence of their cultural integrity on the health of their surrounding ecosystems. So that was, again, an incredible high point in the development of these principles. And then I just wanted to pick up some of the themes, give you a couple of details on the case law that's also been developing. Before I do, we also have the UK Climate and Nature Bill, which is progressing through Parliament at the moment. That is intended to give effect to the 2030 goals of achieving 30% restoration. It's intended to develop and build upon the Environment Act of 2021, not just halting nature's decline, but actually increasing it by 30%. Again, as I say, I think in order to achieve that, we're going to need more than just a bill. But there it is. And then just to give you the references to the three cases which I think have been incredibly important over the past couple of years. We've got the Swiss women case, finding a breach of Article 8 on the basis that the Swiss government had failed in their positive obligations to protect a group of older women from the effects of climate change. Amazing to read that judgment and hear from the advocates involved about the way in which the Strasbourg Court engaged with principles. Secondly, the Friends of the Earth case, the declaration that the net zero strategy adopted by the government of the UK was unlawful again for the second time. And then thirdly, a case brought by one of my colleagues in the room who managed to achieve an incredible result from the Supreme Court, a finding that greenhouse gas emissions from oil extracted from wells burnt as fuel elsewhere were required to be assessed in an environmental impact assessment. They couldn't just be pushed down the road. So that's a real paradigm shift in the thinking on climate change. So just finally, I'm going to go back to waxing a little bit lyrical, if I may. Do we need to rewrite the law to reflect the truth about nature? Answer, yes. Because to be human is to confuse a satisfying story with a meaningful one, and to mistake life for something huge with two legs. No, life is mobilized on a vastly larger scale, and the world is failing precisely because no novel can make the contest for the world seem as compelling as the struggles between a few lost people. So I leave you there with the words of Richard Powers again, and if you haven't read it, do read it. It made me think so differently about trees. I could never look at them the same way again. So for me, the rights of nature analysis enshrined in Ecuador's constitution provides a fundamentally different and, in my view, correct way of seeing a human's place as intrinsically part of the natural world rather than in dominion over it or apart from it. So I would argue that only by giving nature primacy and making human rights a part of nature's overall rights can we truly recognise and therefore stand a chance of meeting the existential threat that exists to our planet. Thank you very much.
So thank you so much. And I love the idea of meeting the existential threat with something that's actually quite powerfully summarised by this expression of civic coexistence. That's definitely some food for thought. So before I hand over to Kyle for the third of our wonderful trio of course this evening, I know some of you are standing at the back. Can I just identify there are a few seats at the front, don't be shy, there are at least 3 here. And if there are any others, please stick a hand up if you've got a seat next to you. Please do take an opportunity to sit down if you want to before the next session. But if you're okay, that's fine. I just want to make sure everyone who needs a seat slot one. Brilliant. Kyle, if I may hand over to you. Thank you so much.
Sure. Well, great to hear about the progress in Ecuador in view of what I'm going to do next, which is to give a quote. I can't do a lecture about Earthball without referring to my favorite quote, which is from an old judgment in the US called Sierra Club versus Morton, 1972. This is more than 50 years ago. At the time, the dissenting judge was William O. Douglas on the court. And this is one of the things, a few things I remember from university, off the top of my head. The case was about the Sierra Club bringing a claim against Disney, I think it was, for building something called the Mineral King Ski Resort in the Sierra Nevada mountains, and they lost. And the majority of the court found that the Sierra Club, believe it or not, didn't have standing back in 1972 to bring such a case. But Douglas was a visionary at the time, and here's what he said. I think it makes a very compelling case for Earth law. And it's a bit long, but bear with me. He says, inanimate objects are sometimes parties in litigation. A ship has the legal personality, fiction found useful for maritime purposes. The corporation soul, a creature of ecclesiastical law, is an acceptable adversary, and large fortunes ride on its cases. The ordinary corporation is a, quote, person, unquote, for purposes of the adjudicatory processes, whether it represents proprietary, spiritual, aesthetic, or charitable causes. So it should be as respects valleys, alpine meadows, rivers, lakes, estuaries, beaches, ridges, groves of trees, swampland, and even air that feels the destructive pressures of modern technology and modern life. Full stop. In other words, now that we have entirely made up figments of people's imaginations having legal standing, why shouldn't real things as well? And I think it's completely rational. So let me start with that, and then say that we've been struggling ever since, and now gratefully, as you know, we have standing or sufficient interest as ENGOs and other claimants to represent the public interest in the environment in court and elsewhere. But what I want to do here is take a couple of the OEP complaints, the Office for Environmental Protection complaints that I'm running, against the prism of 4 principles that I've learned in the course of my practice in UK environmental law, and give some views on what we need to secure or be concerned with and take forward on our journey, ultimately to get to a different system, things that we can learn from now that are in many cases still quite troubling. So I'll give you an overview of the two OEP complaints that we've been working on. The first one is something that I did jointly with WWF UK, which is about agricultural pollution, the control of agricultural pollution in terms of the various sets of regulations, including the Farm Rules for Water and nitrates regulations, and how neither the Environment Agency nor DEFRA are enforcing them properly. So that's the first one that was partially resolved in January of this year by the OEP, when it said, as the OEP usually does on a preliminary basis, it may be unlawful how they've conducted themselves, and they need to go away and think about fixing it. So I'll come back to where we are with that case. The second one is something that's still ongoing, eagerly awaiting a result on. It's around neonicotinoid pesticide use in East Anglia. You might know that for the 3rd or 4th year in a row, the government gave an emergency authorization to the MFU and the sugar beet industry to spray or purchase these distribute these pesticide treated seeds for sugar beet in that region. And you may also know that this is now the outdoor use of such products are abandoned completely in the EU. And one of the early departures from EU law that not many might know about, back in 2019, it was snuck in as something that we could get on with here and authorize while it subsequently became banned in the EU. So those are the two cases. We're waiting for that second one. Hopefully, I mean, I'm hoping it's just heard up. Hopefully in July, maybe we'll hear later in July. We'll hear something about the second case. So, if I'm an NGO representing the public is interested in the environment, and these cases are about habitats and species, then I like to think that somehow I'm helping these habitats and species express themselves, even though this is subject to my personal interests and to some extent our corporate plan, and the fact that I'm trying to do my best to take a guess at what's important, but at least it's a start. On that note, let me point out the four things that I think are a bit troubling that we need to be mindful of as we go forward with our journey here. So the first one I'm going to call safeguarding the baseline, and I think you mentioned this. Irithal's not about replacing the current environmental law system; it's about something bigger. And I want to make the point that it's a perfectly plain point, but it has to be said. Despite all the great things that are going on, for example, in Ecuador, don't think for 1 minute the baseline is safe. Where we've gotten so far in the last 50 years is safe at all. It's not. And I'll give you the reason for that, which you might guess, in terms of the UK example. Let me first say that both of these OEP complaints that I'm talking about depend heavily upon retained EU law, almost entirely. There's only one law, domestic law, in those two, among many grounds in both of those complaints, that is purely based on a domestic statute, which is the Wildlife and Countryside Act, and how it governs sites of special scientific interest. The rest of it is retained, all of it is retained EU law. What is it, you ask? It's the farming rules for water, which are officially reduction and prevention of agricultural diffuse pollution, England Regulations 2019. It's the plant protection regulations, 2009. It's the nitrate pollution prevention regulations. And perhaps closest to my heart, because over the years I've worked as a lawyer in Natural England, the habitats regulations, which, I know it's not an exact match and it's probably not as good, but it's what we were talking about in terms of Ecuador and the species and habitats and the Constitution. It reminded me of how progressive and important habitats regulations are, if implemented correctly. It's a very, very strong piece of environmental legislation. So the agricultural pollution regulations, the farming rules for water, relate to the river pollution complaint that I did with WWF. The plant protection regulations, pesticide regulations relate to the East Anglian sugar beet complaint. And the habitats regulations apply to both. Now, coming on to potential threats, or actual threats, you'll remember the retained EU law revocation and reform bill too long ago, which set out, as originally contemplated by its person who introduced it, that at the end of 2023 there'd be a sunset date, whereas if European law wasn't specifically retained, it would drop off the face of the map. Well, luckily that didn't happen, and Client Earth, other NGOs, business interests, and a wider consortium of peers and others went to work to make sure it didn't happen. And fortunately, that threat was largely eradicated, with certain exceptions that were revoked at the end of 2020. But had action not been taken, I have to pinch myself. Is this real? Yes, it was real. And had action not been taken, the interests, the natural history, natural resource interests I represent in these complaints would not have a leg to stand on, more or less. I might be even out of a job, maybe. Who knows? There'd be nothing left. So there's an example of why, even as we move forward and think about new ways to do things, we have to have a rearguard action in the trenches, constantly alert and armed to make sure that people are not trying to chip away. If there are interests that we're trying to chip away at what's already there. So that's the first point I wanted to make. The next point I want to make is let's implement what's already there in the legislation. How about that? Let's have government leadership and resources and capacity in the civil service to be able to, when they come across a set of facts, to scope what the law provides for and actually do something about it. Right? So this is, I'll use the pesticides OEP complaint to illustrate this one. Well, actually both of my complaints, and they both relate to the Habitats Directive. Now, in the pesticides case, for the third or fourth year in a row, we noticed that the minister never, when he made this emergency decision to use these pesticides in January of each year, never seemed to refer to the habitats regulations, even though you had an area in East Anglia that was more or less defined where sugar beet was grown. There were SACs and SPAs, protected sites, all over the map, and there were many more triple SIs dotted in between those. And the first thing I thought of was local planning authorities and local plans. You know, there are a dime a dozen on the internet. Go look it up. They have a methodology for how you start with a big concept and a lot of sites, protected sites, and you assess it down stage by stage to, you know, some are being eliminated, and there will be no harm caused, so there might be a problem somewhere else. We'll consult with natural language, etc. It's part of the legal process. Never done at all when in the case of what I call a project authorizing pesticides that are banned for outdoor use elsewhere, protected areas that are full of wild bees and aquatic species and all sorts of things. Never done. And finally, I guess they caught on from our information requests and complaining that various other preliminary complaints that it wasn't done. And lo and behold, we got hold of a DEFRA memo, marked official sensitive or something, that says, dear Minister, we probably should do a habitats regulations assessment on this, and this is January of this year, and look at the triple SIs. But it's all very complicated. There's a lot of sites. There's not really much time, so let's just get on with it. That's what it says. So that was sent to the OEP as evidence, and that's with them now, and we'll see what they have to say about that. So, to the Environment Agency's credit, in the other case, the water case, we pointed out that their system for approving derogations to spread manure on grassland, which could impact rivers, also was subject to habitats regulations assessment and should have been consulted upon with Natural England. In fairness, they stood up and said, yeah, we'll start doing it. The OEP is now monitoring that, which is great. So, implement what's already there. Third, let the regulators do their job. Let the regulators do their job. So in our river pollution complaint with WWF, that's one of my examples. We argued that the Environment Agency has a role in enforcing the farming rules for water. They're quite prescriptive and quite obvious. DEFRA, some of you might now have produced this guidance that's lurking there lurking on the internet somewhere from 2022 that says, well, you know, there are certain, you know, we're as a matter of policy, we're going to say that we're going to interpret some of these prescriptive rules quite broadly, and you know, you have a defense of reasonable precautions if you happen to violate any of these rules, etc. And that, you know, in our view, was not lawful. We argued principles around a case called Gillick, which says that policy cannot supplant what the law says or what the regulations require. And on that basis, the OEP agreed and said in January, it said, DEFRA, you should go away and have a look at this. It's probably unlawful and pull this guidance and let the agency get on with overseeing this area. Well, last month, you may have seen the River Action judgment come as well, which interestingly enough, didn't deal directly with this point. In that case, the NGO River Action were saying that the Environment Agency wasn't doing enough to enforce the farm rules. The court said, well, given the factors at play, which I won't get into, they're doing enough. It's within their discretion. But unfortunately, River Action didn't succeed on that point. But what's fascinating about the case, especially for someone who used to work in government, is that if you get yourself a bucket of popcorn and read it very carefully, and you'll get some entertainment out of it, because you'll see something quite unusual, I think, which is the Environment Agency and DEFRA arguing with each other about whose interpretation of the farming rules for water is correct. Bizarre. Now, the DEFRA were joined in this argument by the intervener, the National Farmers Union. And they were arguing broad, expansive interpretation of the rules. You can put fertilizer on the land, in the autumn when you're liable to lose most of it to the environment, and that's okay because it's the most practical thing to do. The agency were saying no. Construed in the purpose of the regulations, the time to do is at application to meet plant health needs, which is only as much as the plant needs in the spring to get grown, and that minimizes pollution. And the court said, I think it was Honorable Justice Dove, said, having reflected on the competing submissions, the Environment Agency is correct. And then he says, it's undoubtedly unfortunate and has not assisted the Environment Agency's enforcement activities that there's been a conflict in the interpretation of farm rules for water between the Environment Agency and DEFRA. So let the regulators do their jobs. And the fourth one is something hot off the press from the Aarhus Compliance Committee last week. Climate has been always very active historically in Aarhus convention matters and getting making the position known on some of the UK's lack of progress. So last week, it's online now, a letter came out on UK progress on implementing Article 9 of the Aarhus Convention, which is around costs in court proceedings. And this goes back to 2021, when the Compliance Committee directed the UK to step up its efforts as a matter of urgency to fulfill the requirements of Article 9. This includes ensuring that the allocation of costs in all court procedures, including private nuisance claims, is fair and equitable and not prohibitively expensive. Number two, further consider establishment of appropriate assistance mechanisms to remove or reduce financial barriers to access to justice. And three, establish a clear, transparent, and consistent framework to implement Article 9 of the Convention. Well, the UK said back in 2020 to consult on this in a call for evidence on the operation of environmental cost protection regime, and it hasn't happened at all. So the final progress report is due on October 1st. The UK has basically done nothing. The committee has expressed its disappointment, and there's a long way to go. There's not much time to October 1st, and a long way to go to produce anything. So, without obviously, it doesn't have to be said that the easier it is to access justice, environmental justice, the more likely people will do it, and the better of nature will be in the process. So there's a problem there. The one bright spot I'll comment on, I think I'm almost bang on time. Amidst all the criticism of government leadership, let me say I think the OEP is terrific. I think they're not only very open and transparent, engaging with the stakeholder community, including the ENGOs, but they're really taking the lead in challenging the direction of things, including some of the information we saw before. And I think it would be very interesting if the next government does take on this task of getting into the Aarhus requirements a little bit more and producing some evidence as to how the UK is getting on, that the OEP's role is taken into account and valued for that purpose. Because as you'll know, it's not only about us making complaints, it's also about the OEP on its own back doing a judicial review or an environment taking an environmental review against government and advising government in other ways on changes to environmental law, etc. So there is, for me, a real hope that they'll play an increased role in the future in allowing more people and the non-human community, as it were, to find a route to justice. So those are my 4 observations. Safeguard the baseline, implement what's already there, let the regulator do their job, and incentivize access to justice.
Thank you so much, Kyle, and yeah, so much more for me to read and understand, and I've made a careful note of all the reading material and points I need to be looking at. It's been absolutely fantastic. We're coming to the point of the evening where we have some questions, but if I could invite Helena and Bonnie to join the panel for this part. Switch seats, you want to go there? We're just having a quick change of seat. Let everyone stretch their legs.
Yeah.
Thank you. So now it's your opportunity to ask questions of our speakers. I'll invite questions from the floor first, before taking some of the questions that we were provided with in advance, and invite people to submit them. So is there anyone in the audience who would like to ask a question? Selena, please go ahead. Could you introduce yourself, Sharon?
I won't stand up, but I'm Selena Cahoon. I'm Vice Chair of the Law Reform Committee, and I see part of my task sometimes to wave these lovely environmental and indeed earth law related issues in front of the committee's nose, and they do an awful lot better than I do when looking at it. I'm going to be greedy. I've got two questions. The first is a general one about Ecuador and what it was that took, why did they have the ability to institute this extraordinary and clearly effective system, and what did it take? And secondly, a small point for Kyle, which was it's wonderful to hear the MEP has the teeth that a lot of us were worried it wasn't going to bear. But also, just in terms of the handbrakes, I thought the most interesting judgment recently was actually Fry, which says the habitat regulations actually are of themselves an effective form of legislation in this country without the need to rely upon the directive rather than Finch. And I just wondered what you thought about that, but forgive me, thank you for letting me ask too.
Thank you, Selena. So should we take those questions in turn? So if we turn our sights to Ecuador, first of all, yeah. Perhaps I could turn to you first, Zoe, and then I'll see if there's any contribution from outside the table. Thank you.
Yeah, so thank you for that question. From what I can gather, because Spanish is not my first language, I think there are 3 things that made it really jump off in Ecuador. The first is an incredibly close connection between the land and the indigenous peoples of Ecuador. Rather like in the Torres Straits, it's all right there in a way that we are somehow slightly divorced somehow from nature here. So it was both obvious and therefore vital there. Secondly, I think it was quite political. I haven't got right to the bottom of all the political changes, but I think that the outgoing president, I think Moreno was called. I did write it down in case you asked me. Yes, Lenin Moreno was, his sort of legacy was to ensure that the independence of the Constitutional Court was guaranteed. And then when the Constitutional Court came into being, and then there were 9 new justices appointed who were effectively appointed, I think, by the incoming president, who wanted to continue this legacy in order to establish an absolutely independent judiciary in a way that perhaps hadn't been the case before. The third reason is that then this judiciary rolled up their sleeves and became quite involved, and they're entitled under the Constitution to call in the cases that they think will give them an opportunity to demonstrate the fundamental rights that of the Constitution, which is quite a sort of activist jurisdiction. So I think it's a combination of those 3 things which brought this all to life.
Thank you. I just check. Helen, did you or probably Helen wants to come on that point at all on the Ecuador point? I don't know Helen. Well, Helen, only been to Ecuador. So
Yeah, sorry, I
think
think you'll know more about it than I do.
Well, I can offer an additional point to that, which is the importance of activist networks, because the first rights of nature law actually was in the United States. It was a local ordinance, the Macrobera sewage sludge ordinance. The very inauspicious beginnings of rights of nature law actually started there, and it was activists who were involved in bringing about that law, who were in networks with activists in Ecuador. So I think one of the interesting things about rights of nature is the role of activist networks in moving these ideas around the world and connecting them with what's meaningful locally. Because rights of nature is not a sort of a cookie cutter thing that you just slot into different places. For it to be meaningful, it has to be connected to local values, cosmologies. So it's going to look different in different places. So that was another important factor I would say.
Thanks, Helen.
Yeah.
So I think your second question was probably one for Kyle.
Yeah, just to say, I mean, I think I've said in the main talk that I consider them to be the most important set of regulations that are now retained with us. And the reason why I think the habitats regulations are so progressive, a global perspective, coming from, being someone who comes from North America, the North American sort of, putting my conservation hat on a second, as opposed to my lawyer hat, the North American model of conservation, which may have a lot in common with South America as well and elsewhere in the world, is that protected areas and protected species are often built, or most often built off the platform or off the back of publicly owned land. Yeah. So in North America and the United States, there's millions and millions of hectares of state and federal land for people to recreate on and for species and habitats to thrive on. And it's within that context that the most protections for wildlife and habitat arise. In this country and in most of Europe, you're dealing with private property. And to think that you have these special designations for flora and fauna imposed on vast acreages of private land is an extremely progressive concept. And then you get into the whole thing around it reminds me of the Ecuadorian constitution, what triggers legal scrutiny. Ecology basically does. That's what drives the appropriate assessment test, underpinned by the precautionary principle, etc. So an incredibly progressive and important jewel in the crown, I would say, of our legal system here, and we will continue to fight for it.
Elena, could I just add something? It's not directly answering your question, but it's just to kind of raise. I think as we've, as you guys have talked in the last little while, just want to add the importance in tandem of the conservation, the species level, the habitats concern, and that is the interest of the individual human animal, as well as the species level. So it's just, as we go forward thinking about conservation, about habitats, about species, about that higher level, is just to think lower in the scale also about the importance of welfare, interests or rights, whatever we're going to think about, but of the individual as well. They need to work together. And some of the things that we have do that. And some of the things that we often talk about when we talk about environment, conservation, earth law, is to think at that higher group level. And that's great. But
I agree. I completely agree. And I should have said it before, but let me just add to that and say, imagine if the concept, the mechanics of something like the habitats regulations, which applies to lines drawn on a map in certain places, applied to individual species, individuals of species wherever they occur. So if I wanted to, step on a house spider in my bathroom, I'd have to have some serious legal consideration first before I do it. So I could if that regime applied to that instance. So I get the point, man, and I agree.
Yeah. I knew that the point of trivia that was raised with me 2 days ago would become relevant, and it has just now, because someone told me that in Germany it is in fact illegal to just try and kill a wasp. I don't know if anyone buried that as true or otherwise. You can't just, for example, spray it with something.
There's a new animal welfare law, I think, in Germany, and I haven't looked at it in that element, like in relation to dogs, but
just asked me by someone who's terrified of wasps and is in Germany. There we go. Thank you both very much. And can I just check there? I think there's another question at the back. Sorry, Paul, I think. Do you want to go next?
Hi, you're sat in front of a banner which has the Bar Council logo on it saying Justice for All over there. Do you agree that Justice for All should include nature, and that therefore at the moment nature's excluded from it? You know, the CAB rank rule doesn't apply to nature because they don't have legal personality and they're not actually represented in most cases. If you agree that nature should come within that banner, how do we convince the Bar Council to explore that and to maybe even have a position that nature should have legal personality so that justice can indeed apply to it? It's maybe a slight campaigning question, but just any thoughts on that?
Zoe's going to take this one, I think, and I'll come in on that in a moment. Thank you.
Frankly, I think it's amazing that we're having this panel, and that's a good start. I think Justice for All should include, personally, not on behalf of the Bar Council, because I'm not speaking at all on behalf of the Bar Council. Personally, I think for the reasons I've said, that we need to be rethinking these concepts. I think it's a journey, and it's a journey that we would like to travel, perhaps some of us more quickly than others. But I think the fact that we are here on the annual Law Reform Committee, and I've been citing Richard Powers in Overstory, frankly, is really impressive. And I think that's a good start. That's what I would say.
Yeah, let's keep having these conversations, I think, is one of the other things, which is let's build on conversations we've already had in the Bar Council. I think it also touches upon something that Helen said when she opened this session about looking at ethics and ethical boundaries as part of the overall oversight of this area of law. So it's a really important area to consider going forward. I'm sorry, there's someone who had their hands up. Sorry, would you mind introducing yourself?
Yes, I'm Sam Knight, colleague of Zoe's. Got lots of so many interesting ideas, and I wanted to actually ask about views on the limitation of judicial review as a tool for this area. I mean, one of the sort of striking things about the Ecuador example is you've got this enshrined substantively in the Constitution, and it seems that so many of our environmental cases, which are being forced through the prism of judicial review principles, are just struggle because you've got, so much deference given the decision maker, etc. So I suppose the question would be, how can we substantively, in the absence of having a complete rethinking immediately, but how can we substantively get some better laws? Do you think it's at local level through regulations, or where are the sort of the pressure points? I mean, I'm thinking, for example, in relation to the protection of the ocean, stop the sewage and the degradation of the ocean, and protection of the trees. I mean, there are so many areas which are so poorly protected at the moment.
So, sorry,
I can
Steve,
give
would you like to?
I can just give a little anecdote in response to judicial review. I mean, it's not going to be a very academic answer to your question, but it gives a flavor of the limitations. A little story. So when we did the most recent climate change judicial review, I was part of that team, Klein Earth and Friends of the Earth. It was referenced before, the plan that needs to be rewritten by next May. It was just to Sheldon, and I was in court there watching the proceedings, and he said, after we presented all of the evidence around the international requirements and the existential crisis, the importance of getting climate right domestically, he said to DEFRA's counsel, well, shouldn't I take an enhanced interest in this case because what's at stake globally? And the answer was no, I'm afraid you're stuck with the ordinary rationality test. So there's a short answer for you on the limitations of judicial review. But that said, luckily it was so irrational that we managed to succeed in that case.
Thank you. Did you want to come in?
Yeah.
Sorry.
Yeah, well, I guess just from the point of view of the book, so this is the judicial review question is something that several of our authors kind of grappled with, and I think and the inability to remake the substantive decision. But I think that often, certainly in the judgments, there were creative ways around this, and there are actually more possibilities open than one might think within existing kind of structures and frameworks. So I guess there's more optimism, I guess, coming from that perspective.
Can I add a very brief point to that? And that's just to sort of take one step back and think actually, I think one of the things we'd be really interested in seeing and encouraging is wider participatory approaches in earlier decision making, so that perhaps that the judicial review point becomes less of a concern. You know, wider methods of engaging other than humans in those processes. And I think if we can think more carefully about who is involved and how they are represented, and I think that's just a broader point, isn't it? One of the key things I think we want to think about is that wider attentiveness to others than simply the human interest in any particular context or decision. So I think if we can kind of consider who is making the decisions and who is involved in those decisions prior, you know, to the decision being made, maybe we can help.
But to go back to actually what Carl was saying, often the principles are already there in our existing legislation, and it's actually a matter of turning our attention to them. And there should actually be more consideration. Yeah.
Thank you so much. So I think, George, you had your hand up, and I've seen a few other hands, and I hopefully clocked you all. But,
yeah, I mean, I wanted to share just a slightly sceptical note following that interesting discussion. I mean, to summarise at the highest possible level, I mean, a lot of what the law is good for in this area is holding politicians to their promises. There's a lot, I mean, it's a sort of overwhelmingly broad brush characterisation of a lot of judicial review in this area. What the courts are actually doing is taking the law, promises to consult, promises to take various environmental matters into account, and making sure that they are holding politicians' feet to the fire. Say, here is the law that effectively you wrote, either as European legislators or UK legislators, and making sure that they comply with it. So it's making politicians walk the walk as well as talk the talk. But if you actually want to alter the substantive law, in the end, in a democracy, you've got to persuade voters to vote for it. And that's a political fight, and it ought to be a political fight. And I was just thinking about your point about sort of involving non-human interests. I mean, ultimately, we're in a democracy. I mean, the job of politicians in a democracy is to represent voters. And I'm not sure quite how you sell to voters the idea that things that are actually, I mean, I think it's slightly difficult to reconcile the idea of sort of non-human interests with democracy, the idea of one person, one vote.
Can I just respond to that? I'm just thinking about governments, they don't just serve the interests of voters, because, for example, children can't vote. And we obviously want to serve their interests. So if governments are not just serving the interests of voters, if it extends to other people who cannot vote, then logically, why not extend it to the non-humans as well?
Well, yes, but then voters care about children. So that's why governments care about children. Ultimately, if government said we don't care about children, they lose votes. And yeah, I mean, you have an argument about whether the voting age is the right place and so on. But I'm not sure that's our argument really answers the principle. That I think there is a tension between saying it's sort of devising political structures in which non-human actors have some sort of voice, which effectively means people, because trees can't talk. So you're then giving some people a privileged status over because they have more than one vote, because they're voting for themselves and for the trees, to characterise it in a very simplistic way. And I think there is a tension between that and the basic principle of democracy, which is one person, one vote.
Yes, if you want to come up with one point, then we'll probably go to the next question. Not because I want to curtail this really interesting discussion, but just because I'm keeping an eye on the time as I must.
I think it's a really good point, is that there is, as Sam Knight said, there is going to be a limit to what judicial review can achieve. And there is going to be a limit to a sort of rationality analysis. There's also going to be a limit to what a voter can vote for. But there's not going to be a limit to a voter who can vote for legislative change, which involves the protection of the earth as a fundamental principle. And there's also not going to be a limit to courts being able to uphold fundamental rights, which encompass the rights of nature and the rights of people to live. So I think rather than worrying too much about people being able to, having to give animals the vote, which I don't think we're necessarily going down that road, but I think it's just about informing the populace about what a crisis we're in and what the answers are, and ensuring education of the public insofar as it's not being, but also empowerment of politicians. And hopefully once we're, to add a slightly political, hopefully once we're past this week, we might, there might be a whole new world. Who knows?
Thank you. I'm going to take two more questions, and then I'm going to suggest that any other questions are over an informal drink afterwards. So, gentleman on the front, would you mind just introducing yourself briefly?
I'm Laurie Sher. So 20 odd years ago, a bunch of people registered village greens in their local area, and they became protected from development. How are sites of special scientific interest identified by Natural England and then registered or similar? Is there a way that the public can get involved in identifying areas of high biodiversity, for example?
Wow, that's a good question. Well, I mean, the selection mechanism for triple SIs is under the Wildlife and Countryside Act 1981. That's when you have to look for on that. And they, Natural England largely, at least when I worked there, used to coordinate that process. And there'd be a consultation process with the landowner involved, other stakeholders, and the whole governance process around preliminary notification and the final notification. But I can't recall the public necessarily having active involvement in that. But there are new laws which I don't have at the top of my head at the moment around local nature recovery plans and things like that, which may engender more public involvement. It could lead to triple SI conservation.
Thank you. So I think the last question I'll take is from Lorna, if you still have your question, and then we'll look to that. But thank you, Lorna.
So my question is about animal rights, and I'm not speaking with any form of bar council or law reform committee hat on. It's very much sort of personal interest. But I was wondering if, when we're looking at improving laws for animal well-being, there isn't rather a cognitive dissonance between what we're talking about in terms of wildlife species, such as river mammals, bees, and a farming industry, in particular a heavily industrialized meat and fish farming industry, the fates of which sort of sentient beings in that arena tend to be viewed very differently in the public sphere, if people think about it at all, which often they try not to, I think. And I was wondering if you can make meaningful progress on enhanced recognitions and protections for animal rights and well-being without tackling that quite fundamental split.
I think I know who might be taking this question.
Yeah, thank you for that. Yeah, no, I mean, obviously you make a really good point. There are some really awful in the sense ethically awful, but also highly complex underpinnings, I think. And when you look at the question of how do we move forward in terms of advancing animal interests, and it is often easier, I think, to talk about the wildlife, to think about animals that are outside of the ones that we consume. Yeah, the consumption and the division of animals into companion animals, eating animals, and fabulous wildlife potentially, or pests. You know, over there it's a lovely, it's important biodiversity, And over here it's a pest, and the law says over there I must protect it under, and over here I can absolutely lawfully kill it in whatever inhumane way I want. So yes, I think it's really difficult to move forward until we address that. The addressing of farmed animal interests, I think, is potentially going to be one of the slowest, because I think until we move from it being a very important commercial dimension, a very normalized dietary activity, it is incredibly difficult to think about granting those animal rights. It's much easier, potentially, to think about the rights of nature direction in terms of granting rights to animals that exist in a forest that are separate from those that exist in the big unit down the road that we would have on Sunday. You know, I don't know that I've got any good answers for that. I think that the first task is to think about improving the welfare of those animals and improving our understanding of the experiences that they have in the conditions that we put them in, and to move people's understandings of what it is that we are doing when we engage in intensive animal agriculture and what it means to eat those animals, not only for them, but also for the other dimensions that we want to think about. You know, Zoe talked about the State of Nature report and biodiversity law. Intensive agriculture is a fundamental driver of that in the UK. You know, pollution, water pollution, every dimension of intensive agriculture has a serious problem, and animal interest is only one of those. So I think it has to be about education and change of the normalization of that form of diet. And only then, as we start to disturb that, I think we will be able to take that forward. I think it does work to think about the rights of perhaps other animals first and move that forward. Companion animals often seems to get a better response, right, from voters, because they are the ones, you know, that the pictures outside are people with their dogs and their cats. There's nobody out there with a pig or their cat, right? But for reasons that, you know, it is political, isn't it? It's emotional. You have to get people in some way first. So I think it's education in relation to farmed animals, rights in relation to others, potentially. I'm ambivalent about rights in some ways, but and I think we move forward in a messy way. I'm sorry, it's a terrible answer, but it's a terrible question.
I'll add something interestingly, that goes back to one of the regulations that that we're working on. So we mentioned the pesticides regulations. These are European direct effect regulations from 2009. And interestingly enough, in those regulations, it's an issue in our case. There's a distinction in terms of causing harm through authorizations between the decision maker shouldn't cause any harm to human health or animal health, meaning domesticated animals that are used for food production, right? Because of the inherent human interest in it, from an economic point of view. But the second test is, or any unacceptable effects on the environment, meaning if you're a wild species in that case, what's acceptable and what's not.
So it's interesting,
so
isn't it?
There you go.
Yeah, because sometimes we think it's easier, perhaps in some ways, to think about moving towards rights of, wildlife, and actually sometimes the legal protection is terrible for some species. Others, far more consideration. It's incredibly random at some level, and all guided by our interests in them, or our lack of interest in the wasp in your bathroom or the rat in your kitchen.
Thank you so much. I absolutely loathe to put an end to this absolutely stimulating discussion. I for once have found all of these talks actually positively enriching. Give me so much to think about. I really enjoyed them, and I'm tremendously grateful that you've come spoken to us and delivered the annual law reform lecture this year. Can we thank our speakers in the